Kia ora. It's a great pleasure to be here virtually with you for the conference Extraction Tracing the Veins, and I very much look forward to our online exchanges these days. This paper is ongoing work, which is part of a larger project called the Juridification of Resource Conflict, Legal Cultures, Moralities and Environmental Politics in Central America, which is led by Ainhoa Montoya at the School of Advanced Study at the University of London, and involves collaboration between the school and CSS, where I am in Mexico City and where Yakotzin Bravo also is. It's funded by the British Academy, and it seeks to examine the uses of the jural in context of violent conflicts over subsoil resources in Central America and Mexico. And this paper is on the juridification of indigenous people's struggles in defense of territory, lessons from the Marlin mine in Guatemala. The Marlin mine was located in the municipalities of San Miguel Ixtahuacan and Zipacapa in the region of San Marcos, Guatemala, and it's perhaps one of the clearest and earliest examples of multi-scalar juridification against extractive industries in Central America. Marlin was the second largest open pit gold mine in Latin America, and it commenced exploitation in 2003, some 4 years after the first license for exploration was granted. It ceased operations in May 2017, and it finally closed permanently last year in 2019. The municipalities of San Miguel Ixtahuacan and Zipacapa are predominantly inhabited by rural Mayan, Mam and Zipacapense villages. How then should we approach the concept of juridification? As I've argued elsewhere, juridification can involve judicialization, that is the displacement of political battles to the courts, but it in fact signals a much broader phenomenon. In the literature, the concept of juridification has been understood as a form of legal framing, whereby people come to see themselves as legal subjects through the process or processes of claiming rights. So identity transformations occurring whereby people come to see themselves as subjects of rights. It also refers to processes of legal or law-like legal ordering, wherein courts or other agents, such as NGOs or international organizations, demand certain standards of legal and organizational legibility from their subjects. And a defining feature of contemporary juridification processes is that they occur within these complex, multiscalar forms of global legal pluralism involving the overlapping of different legal and administrative orders and jurisdictions. In the case of Marlin Mine, there were multiple legal and administrative actions initiated against the Guatemalan state in response to the granting of the license to Montana Exploradora de Guatemala, which was a local subsidiary of the Canadian-based multinational mining company Francisco Gold Corporation, which subsequently became Glamis Gold, which then became Goldcorp. And Goldcorp assumed the concession at the Marlin mine in 2009. And over more than 2 decades since the original license to explore and exploit silver and gold through open pit mining in San Miguel, Ixtahuacan and Zipacapa was issued in 1996, the original license. After that, actions were initiated by local lawyers and NGOs before the Guatemalan courts, before the Inter-American Commission, and also before the World Bank's Compliance Advisory Ombudsman. This last because the loan that the bank's International Financial Corporation had extended to the Marlin project was actually in direct contravention of the bank's directives on indigenous peoples, which stipulated the need to guarantee international collective rights to free, prior and informed consultation. Mayan villagers in the affected regions mobilized to organize community consultations, or consultas comunitarias de buena fe, sparking a wave of similar paralegal political protests opposing extractive mega projects across the entire country in the period between 2005 and 2010. However, although Guatemala's Constitutional Court upheld communities' rights to organize such consultations, it also ruled that the outcomes of such exercises were not legally binding because Guatemalan law holds that subsoil resources are the property of the state. Other forms of juridification also occurred, kind of legal mimesis, informing a series of civil society trials or tribunals against the multinational corporations implicated in the Marlin mine. Here in 2012, I took part in a civil society health tribunal to try Goldcorp that was organized in San Miguel, Ixtahuacan. And in the late 2000s, the Marlin mine was the subject of the proceedings of the Permanent People's Tribunal dealing with Canadian mining in Latin America. The range of grievances presented in juridified actions outside the courts and the formal structures of the state and international organizations was complex and broad. But almost all the formal legal and administrative actions undertaken against the Marlin mine invoked the figure of free, prior and informed consultation, which is the right granted to Indigenous peoples by the International Labour Organization's Convention 169, which had been ratified by the Guatemalan government in the late 90s. And this collective right to free, prior and informed consultation, as we know, was strengthened to free, prior and informed consultation for consent, which is set out in the UN Declaration of the Rights of Indigenous Peoples, ratified by the General Assembly in 2007. And for at least 2 decades, free, prior and informed consultation has been at the heart of Indigenous peoples' juridification initiatives to contest extractive industries across Latin America. So legal actions lodged to protest the lack of free, prior and informed consultation about these projects. 10 years ago, in a volume I edited with Alex Huneeus and Javier Causo on judicial politics, I wrote, and I quote, "Over 10 years since ILO 169 was first approved, prior consultation remains an unsettled and vague legal concept. For this reason, it has destabilized existing understandings of law and generated both new forms of legal mobilization and judicialization, specifically processes of juridification." I would want to suggest here that juridification efforts to resist extractive industries in Guatemala have now entered a new period. And my findings are based on an analysis of 2 decades of multi-scalar judicialization, juridification of resistance to the Marlin mine, which centered on free, prior and informed consultation, but also it's based on my ongoing ethnography and active collaboration with collectives of Mayan lawyers in Guatemala over the last few years. Current juridification initiatives to resist extractive projects in Guatemala are today characterized by efforts on the part of Mayan activists and lawyers to go beyond the administrative and political constraints of consultation and instead frame arguments about colonial dispossession of land, territorial control, and the political and legal autonomy of indigenous communities and peoples. As a wealth of comparative literature over the last few years in Latin America has suggested, after 2 decades, it is increasingly clear that while the legal and administrative frameworks of free, prior and informed consultation have been a conduit for resistance, they have effectively become a means to manage that resistance and to displace claims for self-determination. A lot of contemporary juridification revolves around the defense of territorial defenders who are criminalized in multiple forms. So, for example, leading Mayan lawyer in Guatemala, Jovita Sul, has shown how women community defenders who act as translators in legal cases where villagers are trying to defend their lands or their water resources. Those women are increasingly and systematically being charged with criminal offences such as threatening behaviour, instigating criminal behaviour, or aggravated usurpation. So this kind of criminalisation is certainly ongoing, and I think we can say it's getting worse. But the shift in juridification that I want to point to is that these processes of judicialisation, but also juridification beyond the courts, now centres much less on this figure of free, prior and informed consultation, and much more on the reivindication of Indigenous peoples' sovereignty over territory, pointing to forms of juridification that attempt to signal and conceptualise long-run forms of harm, or in Rob Nixon's terms, slow violence, which many Indigenous people, of course, conceptualise as genocidal colonial violence. My recent experiences in the field accompanying Mayan lawyers, accompanying the communities who were affected by the Marlin mine, have made me think much more about the intersections between these processes of slow violence and the dynamics of juridification. For example, I've been involved in some strategy meetings to try and develop proposals for a closure plan for the mine, which would seek to, quote unquote, repair or at least compensate to some extent the damage wrought on affected communities by the presence of the Marlin mine. This, of course, is after the company has effectively abandoned the site, having extracted all that was profitable to take, leaving the communities with a legacy of 2 decades of environmental damage and intracommunal and intra-organisational conflict, and of course the legacies of criminalisation. Such damage, which forms part of colonial continuums of harm, is irreparable and unquantifiable. It can't be translated into legal or administrative measures, at least it always exceeds those. And the critical anthropological literature on transitional justice of recent years has led us to question this notion of what's repairable and what can be repaired through law. I don't have time to talk about it in great detail here, but we've also learned a lot from the Marlin case in terms of the kind of lawfare that the government and the companies employ. So fabricated charges, campaigns of defamation, and efforts to tie up activists in court with never-ending criminal procedures, all of which are aimed at undermining community resistance. And there was a particular focus in the Marlin case on criminalising women who were resisting despoilment of their territory by Gold Corp. Today, juridification efforts in Guatemala have witnessed a shift towards then conceptualizing long-run continuous colonial damage and dispossession, and longer-run notions of historical and intergenerational justice. Mine lawyers collectives are shifting their focus, for example, employing ethno-historical special expert witness reports to evidence the state-sanctioned stealing of Indigenous communal land in the 19th century in claims for territorial restitution. And here this photo is of plaintiffs from a paradigmatic case of recent years, that of Los Copones in the Ixcan, which won just such a claim for territorial restitution. And political legal strategies today focus much more centrally on strengthening communal organization and governance, which is generically referred to in Guatemala as autoridades ancestrales, ancestral authorities. So defending territory is less centered on protesting the lack of respect for upholding collective rights to free, prior and informed consultation, and it's much more focused on strengthening autonomous Indigenous governance and legal authority, or Indigenous peoples' forms of law. So to wrap up, Should we understand the experiences of multiple forms of juridification in resistance to the marlin mine as a failure or as an important learning curve? Across Latin America more broadly, it seems we're at the end of the phase of juridification around the right to free, prior and informed consultation for consent. It's certainly still used, but as I've emphasised here, it's not the primary strategy. And the heart of strategic litigation, or emerging strategic litigation against extractive projects, now focuses on challenging colonial dispossession of indigenous lands. Juridification is just one part, of course, of broader political strategies to strengthen organisation and territorial control or indigenous sovereignty. And I think in the coming period, these conflicts over territory and extraction are likely to become even more acute and even more violent. And for these very reasons, the just generative forms of legal and political organising by Indigenous peoples and their allies will continue to play a vital role in resisting the juggernauts of extractive industries. Muchas gracias. Thank you for your attention.